SwayamPrabha. Digital India. Educated India.
Namaskar students, welcome to SwayamPrabha. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing this course on Bharatiya Nyaya Sanhita 2023 Substantive Criminal Law. Students, this has been a 20-hour course, and today in the 20th session of this course, we will be dealing with miscellaneous provisions, those that could not be covered till now. So, in this session, we will be dealing with some important provisions which we need to know before we can finally say that our course on BNS 2023 has concluded. So, let us talk about those provisions. First of all, let us understand the concept of joint liability. So, students, in criminal law, we ordinarily impose only individual liability. A person can be held criminally liable only for his or her own actions. But there are certain circumstances when what happens that the crime is committed by a large number of people. So, as it is, the law wants to discourage such unlawful assemblies of people, and in which especially those assemblies, they have the objective to commit such unlawful activities. Secondly, when a single crime is committed by more than 2, 3, 4 people, sometimes what happens, it becomes very difficult to exactly find out which injury was inflicted by which person and what exactly is the share of liability of one individual. In such cases, what the law does is imposes joint liability. But then again, that joint liability is not to be imposed blindly. It is to be imposed if only the prosecution succeeds in proving that all the accused persons acted in furtherance of either a common intention or a common objective. So, if it can be proven that they were all acting in furtherance of some common intention or some common objective of the unlawful assembly, then irrespective of the actual part which was played by either one of them, the liability that would be fixed on each one of them would be the same. And that is the concept of joint liability under criminal law. So, let us try and understand the concepts of common intention and common objective. See, section 3 of the general explanations, it explains what is common intention. It says, when a criminal act is done by several persons in furtherance of the common intention of all. So, what is required is, first, the act in itself should be criminal in nature, and the act should be done by several persons. So, what this means is that the involvement of several persons should be there. This term, several persons, how do you construe it? That is more than one person, means several persons in furtherance of common intention of all. So, what is important is that there has to be a meeting of minds, there has to be a commonality of intention, and that meeting of minds should be in respect of all those people. So, commonality of intention of all. It should not be that, see, there are 4 people, 2 people have a common intention and the third one might just be having some sort of a same or similar intention. See, same intention, similar intention are different from common intention. In order to impose joint liability, what is required is common intention. For that, there has to be a sharing of such intention between people, so as to develop a commonality in respect of the intention. So, it is only common intention and not merely same or similar intention that will make a person liable to joint liability. So, what does the law say? When a criminal act is done by several persons, so there is involvement of more than one person in furtherance of common intention of all. Common intention, sometimes it can develop on the spot, but what is required is that the common thread of intention that is shared between two people. And again, common intention must exist at the time of crime. See, an intention which becomes common post the commission of the crime is not sufficient to impose joint liability with the help of section 3. What is required is that if we are talking about common intention, it has to pre-exist the crime. It has to exist either prior to the commission of the crime or at the time of the commission of the crime. Arising subsequently will not entitle the accused to be punished with the help of joint liability. So then what happens if all the accused persons have done an act in furtherance of common intention which was shared by all of them, then each of such persons is liable for this act in the same manner as if it were done by him alone. So liability of each one of them would be the same, irrespective of the actual part that was played by either one of them in the offence. Now coming to common object. Under section 190 of the BNS, every member of unlawful assembly is guilty of offence committed in prosecution of common object. So 190 also imposes a joint liability, but for 190 what is required is that one should be a member of an unlawful assembly. That is, it should be an assembly consisting of minimum 5 members, and it should have assembled with any of the unlawful objectives as have been prescribed by the law. Then in such cases, every member of unlawful assembly shall be guilty of an offence whatever is committed in prosecution of common objective of such unlawful assembly. What does the provision read? It says, if an offence is committed by any member of an unlawful assembly. See, in an unlawful assembly, there are minimum 5 number of people. But if an offence is committed by any member, so out of those 5 people, even if one person has committed the offence, still liability would be joint. But what is required is that the offence should be committed in prosecution of the common objective of that assembly or such as the members of that assembly knew to be likely to be committed in prosecution of that objective. Either it was something which they knew that this is the common objective, or which they knew that in prosecution of this common objective, this can also happen. There is a likelihood of this crime also taking place. So it is this knowledge which is common to all of them. So because they are sharing the common objective. So either there is an intention or there is a knowledge of likelihood of that crime also taking place. Then every person who at the time of committing of that offence is a member of the same assembly is guilty of that offence. So liability would be the same on part of all the accused persons, irrespective of the actual role that was played by either one of them. So irrespective of the fact that one of them was just standing guard, the other one was having a weapon, some third person did some other act, the liability would be the same on all of them, and it is what is known as the principle of joint liability in criminal law. Now coming to provisions relating to riot and affray. So what is rioting? As per section 191 of the BNS, whenever force or violence is used by an unlawful assembly. So again students, whenever we talk about unlawful assembly, we have to understand that it is an assembly with an unlawful objective in which there are a minimum of 5 persons. So whenever force or violence is used by an unlawful assembly or by any member thereof. Who is an unlawful assembly member? One who, despite having knowledge of the unlawful objective of that unlawful assembly, continues to remain in that assembly. One who does not disassociate himself from that assembly despite knowing that these people, they have assembled for an unlawful objective. So mere presence there, mere continuing in such an assembly makes a person a member of unlawful assembly. What is required is to be proven here is that one, the person should be present there, and second, he should have knowledge of the unlawful objective of such assembly. So, whenever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object of such assembly, every member of such assembly is guilty of the offence of rioting. So, when that unlawful assembly is using any kind of a force or violence, it amounts to the crime of rioting. Whoever is guilty of rioting shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. And whoever is guilty of rioting being armed with a deadly weapon or with anything which used as a weapon of offence is likely to cause death shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. Now, what amounts to affray? Section 194 defines what is affray. It says, when 2 or more persons by fighting in a public place disturb the public peace, they are said to commit an affray. So, it is so simple, 2 people, there have to be minimum 2 people when they are fighting amongst themselves, and they are fighting at a public place and they are creating some sort of a disturbance in the society. They have disturbed the peace of that place where they are fighting in a public place. That amounts to affray. If there are more than 2 people fighting, that is again affray, but there have to be minimum presence of 2 people, and they should be fighting actual physical battle amongst themselves, and this should take place at a public place. And what should happen because of that? Peace is disturbed. So, that amounts to the crime of affray. Whoever commits an affray shall be punished with imprisonment of either description for a term which may extend to 1 month, or with fine which may extend to 1000 rupees, or with both. So, fighting in a public place, disturbing the peace of that public place, that is a crime punishable under the law. Then, liability of owner, occupier, etc. of land on which an unlawful assembly or riot takes place. See, ordinarily in criminal law, a person is to be punished only for his or her own unlawful actions or unlawful omissions. But sometimes you can be held responsible for others' actions. So, in a way, the liability, the concept of vicarious liability, which is usually employed in civil offences, this is one provision wherein we constructively apply liability upon the owner or occupier of land on which an unlawful assembly or riot takes place. What does the law say? Whenever any unlawful assembly or riot takes place, the owner or occupier of land, see, it could be either the owner or one who is in the lawful possession of that land, that is the occupier of the land, upon which such unlawful assembly is held or riot is committed, and any person having or claiming an interest in such land shall be punishable with fine not exceeding 1000 rupees if he, his agent or manager, knowing that such offence is being or has been committed, or having reason to believe it is likely to be committed, do not give the earliest notice thereof in his or their power to the officer in charge at the nearest police station, and do not, in the case of his or their having reason to believe that it was about to be committed, use all lawful means in his or their power to prevent it. And in the event of its taking place, do not use all lawful means in his or their power to disperse or suppress the riot or unlawful assembly. So, what is the owner or occupier required to do? One, he is supposed, there is a legal obligation on such person to inform the authorities. Second, to prevent such a thing taking place. And third, if such a thing has taken place on his premises or on his land, he has to take every step to suppress such thing or to stop it from continuing any further. See, the law gives certain powers to the owners or occupiers, and at the same time they have certain responsibilities also to ensure that nothing unlawful takes place on their premises. So, they have to take a stand in order to stop such unlawful activities from taking place on their premises, and if they do not do so, even they can be held responsible. Then subsection 2 of section 93, it says, whenever a riot is committed for the benefit or on behalf of any person who is the owner or occupier of any land respecting which such riot takes place, or who claims any interest in such land or in the subject of any dispute which gives rise to the riot, or who has accepted or derived any benefit therefrom, such person shall be punishable with fine if he or his agent or manager, having reason to believe that such riot was likely to be committed, or that the unlawful assembly by which such riot was committed was likely to be held, shall not respectively use all lawful means in his or their power to prevent such assembly or riot from taking place, and for suppressing and dispersing the same. So, they have the responsibility to inform the authorities. In case they come to know timely, they should take all steps that they can to prevent such a thing from taking place on their premises, and if it happens, then to take steps to suppress it and prevent it from continuing any further. Then let us understand the concepts of wrongful restraint and wrongful confinement. See, restraint is in a particular direction. When we talk about confinement, we are referring to certain circumscribing limits. That is, when a person does not have the liberty to move in any direction, that would be confinement. And when the person does not have the liberty to move in any specific direction, that would be restraint. What does the law say? Section 126 defines what is wrongful restraint. It says, whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. So, what is required is voluntary obstruction. Okay. You have not done anything, but a person is not able to move in a particular direction. Now, you are not responsible for that. What is required is that voluntarily obstruction. It could be by any means, but the obstruction should be done voluntarily by the accused person, and it should be on account of such obstruction that a person is not able to move in a direction where that person has a desire to move, and there is no lawful impediment to his moving in that direction. If you do that, law holds you responsible for wrongful restraint. See, explanation. The obstruction of a private way over land or water which a person in good faith believes himself to have a lawful right to obstruct is not an offence within the meaning of this section. Over your own private property, you have a right to impose obstructions and all. Aapki apni private property, you can do whatever you want to do over such property. The law will not hold you guilty, provided that should be your own property and you should have a lawful right to obstruct, or you should be acting in good faith while obstructing that. That would not be an offence within the meaning of this section. Look at the illustrations. A obstructs a path along which Z has a right to pass. A, not believing in good faith that he has a right to stop the path, Z is thereby prevented from passing. A has wrongfully restrained Z. Then illustration. So, you see in this illustration that what has A done? He has obstructed a path along which Z had a right to pass, whereas A did not believe in good faith. How do we ascertain the good faith of a person? When a person has acted after exercising due care and precaution. So, if a person has lacked the good faith, it means the person has acted malafide. So, such acts would amount to wrongful restraint. Then, whoever wrongfully restrains any person shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 5,000 rupees, or with both. Coming to wrongful confinement, section 127 says, whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits. That is, the person is not allowed to move in any direction, in any of the directions, all four sides. That is what is known as circumscribing limits. So, whoever wrongfully, wrongful restraint, wrongful confinement. What amounts to wrongful actions? That is when you don't allow a person to move in a direction where the person has a right to be. The person has no lawful impediment to his movement in that particular direction or in any particular direction, and when you prevent such a person from moving, that would amount to a wrongful action. So, whoever wrongfully restrains any person in such a manner, it could be by any means, as to prevent that person from proceeding beyond certain circumscribing limits, is said wrongfully to confine such person. See, sometimes in an open ground also there can be a confinement. The ground is open, but this person is not free to move because you have placed obstructions in all the directions. So, even though it is not a closed room, still it would amount to wrongful confinement if the person is not free to move in any of the directions where he wants to do, if circumscribing limits have been placed on him. See illustrations. A causes Z to go within a walled space and locks Z in. Z is thus prevented from proceeding in any direction beyond the circumscribing line of wall. A wrongfully confines Z. A places men with firearms at the outlets of a building and tells Z that they will fire at Z if Z attempts to leave the building. A has wrongfully confined Z. See, you are not allowing a person to move in any direction, not allowed to exit from any of the exit of the building, because you have threatened the person that there are people armed and they will shoot at you if you leave the building. That is wrongful confinement. Although the person has been confined in a huge building, but still if he wants to leave, he is not free to leave. So, that in itself would also amount to wrongful confinement. See, whoever wrongfully confines any person shall be punished with imprisonment for either description, which may extend up to 1 year, and whoever wrongfully confines any person for 3 days or more shall be punished with imprisonment of either description for a term which may extend to 3 years, and whoever wrongfully confines any person for 10 days or more, then the punishment will be imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. See, students, lawmakers have taken the crime of wrongful confinement very seriously, and that is why if you have been assaulted in a way that you have a reasonable apprehension that you would be subjected to wrongful confinement in a way that you will not be able to have recourse to protection of public authorities to secure your release, then in such cases the one who has been wrongfully confined has a right of private defense, and the right of private defense of such a person extends to even causing the death of the person who has tried to confine him in such a manner. Then whoever keeps any person in wrongful confinement knowing that a writ for liberation of that person has been duly issued shall be punished with imprisonment of either description for a term which may extend to 2 years in addition to any term of imprisonment to which he may be liable under any other section of this chapter and shall also be liable to fine. Then whoever wrongfully confines any person in such manner as to indicate an intention that the confinement of such person may not be known to any person interested in the person so confined or to any public servant, or that the place of such confinement may not be known to or discovered by any such person or public servant as herein before mentioned, shall be punished with imprisonment of either description for a term which may extend to 3 years in addition to any other punishment to which he may be liable for such wrongful confinement and shall also be liable to fine. Now, moving further, whoever wrongfully confines any person for the purpose of extorting from the person confined or from any person interested in the person confined any property or valuable security or of constraining the person confined or any person interested in such person to do anything illegal or to give any information which may facilitate the commission of an offence shall be punished with imprisonment of either description for a term which may extend to 3 years and also fine. Then whoever wrongfully confines any person for the purpose of extorting from the person confined or any person interested in the person confined any confession or information which may lead to the detection of an offence or misconduct, or for purpose of constraining the person confined or any person interested in the person confined to restore or to cause the restoration of any property or valuable security, or to satisfy any claim or demand, or to give information which may lead to the restoration of property or valuable security, shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. So, you see herein wrongful confinement, even if it is done by public servants to in a way pressurize the accused persons, that is also not permissible as per the law. Next, we will talk about offences relating to religion. Students will live in a secular country. What does that mean? We all have a freedom to follow our religious practices, and we also have a freedom to perpetrate our religious beliefs. So, what does it say? Section 298 talks about injuring or defiling place of worship with intent to insult religion of any class. It says whoever destroys, damages or defiles any place of worship or any object held sacred by any class of persons with the intention. See, intention is very important here, and what should be the intention? Of thereby insulting the religion of any class of persons, or even if intention is not there, but at least knowledge is there that any class of persons is likely to consider such destruction, damage or defilement as an insult to their religion. Then such acts of destroying, damaging or defiling any object of worship or any place of worship, when it is done either with the intention or knowledge, then it would be punished with imprisonment up to 2 years. Next is deliberate and malicious acts. Deliberately, voluntarily, designedly, you intentionally do something, and that act is also malicious, that is with malice, with an ill will you have done that act. And what was the intention behind the act? To outrage religious feelings of any class by insulting its religion or religious beliefs. Then what does the law say? Whoever with deliberate and malicious intention of outraging, offending the religious feelings of any class of citizens of India by words, either spoken or written, by signs or by visible representations, or through electronic means or otherwise, insult or attempt to insult the religion or the religious beliefs of that class, then punishment would be imprisonment up to 3 years. See, everybody's religious feelings, religious freedoms, they need to be protected. Disturbing religious assembly. Section 300 says whoever voluntarily, see what is important here is the element of voluntariness. So, whoever voluntarily causes disturbance to any assembly, and the assembly should be lawfully engaged in the performance of religious worship or religious ceremonies, then such a person shall be punished with imprisonment up to 1 year. Then trespassing on burial places. See, there are great religious sentiments attached to the last rites that are prescribed under any religion. So, if anybody trespasses on burial places, that is also deemed to be a punishable crime under the BNS. What does the law say? Whoever with the intention, what is the intention? Of wounding the feelings of any person, or of insulting the religion of any person, or with the knowledge that feelings of any person are likely to be wounded or that religion of any person is likely to be insulted thereby, commits any trespass in any place of worship or any place of sepulture or any place set apart for the performance of funeral rites or as a depository for the remains of the dead, or offers any indignity to any human corpse or causes disturbance for persons assembled for the performance of funeral ceremonies, shall be punished with imprisonment of either description for a term which may extend to 1 year. Then, uttering words with deliberate intent to wound religious feelings of any person. So, what does the law say? Whoever with the deliberate intention of wounding the religious feelings of any person utters any word or makes any sound in the hearing of that person. So, you have done that, and you have done that deliberately in a way that the other person whom you intend to offend or whose religious feelings you intend to outrage is able to hear that thing. You have deliberately done that, okay, or makes any gesture in the sight of that person. So, here again there is this element of deliberately provoking that person by doing something which that person has seen or by saying something which that person has heard, or places any object in the sight of that person, shall be punished with imprisonment of either description for a term which may extend to 1 year. Next, we will talk about a concept which is very important in criminal law, and that is the concept of harbor. What does the term harbor mean? It includes supplying a person. So, this is something which has been defined under section 2 clause 13 of the BNS, and harbor has been defined as including. So, this is an inclusive definition which says harbor includes supplying a person with shelter, food, drink, money, clothes, arms, ammunitions or means of conveyance, or the assisting a person by any means whether of same kind as those enumerated in this clause or not, to evade apprehension. A person is running from the law, a person is suspected of committing a crime, or the person might have committed the crime, and in order to evade apprehension the person is trying to run away, and you are either concealing that person. And why that person is able to stay concealed for a long time? Because you are providing food, water, shelter and all. Or if you are assisting that person in running away by providing a conveyance to such a person, providing money to such a person, or even if you are assisting that person to evade apprehension by providing arms and ammunition to such a person. So, that all amounts to harboring of offenders under the law. What does 249 say? Whenever an offence has been committed, whoever harbors or conceals a person whom he knows or has reason to believe to be the offender with the intention of screening him from legal punishment. The intention behind harbor should be to screen the person from legal punishment. Then in such cases, what would be the punishment awarded to the person who has harbored the offender? If the offence will be punishable with death, then what is the punishment that will be prescribed? If the offence is punishable with death, the person shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. See, what has the person done? He has just shielded that person from being apprehended by the law authorities, and merely shielding that person would also make the person punishable for a crime. And look at the amount of punishment, 5 years imprisonment. That would be awarded in cases where the accused who was to be apprehended, whom you have shielded, had committed an offence which was punishable with death penalty. Next, if the offence is punishable with imprisonment for life or with imprisonment which may extend to 10 years, then be punished with imprisonment of either description for a term which may extend to 3 years and also be liable to fine. If the offence is punishable with imprisonment which may extend to 1 year and not to 10 years, be punished with imprisonment of the description provided for the offence for a term which may extend to 1/4 part of the longest term of imprisonment provided for the offence, or with fine, or with both. There is, however, an exception to this. This section shall not extend to any case in which harbor or concealment is by the spouse of the offender. So, no matter what is the offence that has been committed by one of the spouses, if the other spouse shields that offending spouse from punishment, that would not be covered under this definition. Look at the illustration. A, knowing that B has committed dacoity, knowingly conceals B in order to screen him from legal punishment. Here, as B is liable to imprisonment for life, now why is B liable to imprisonment for life? Look at the offence that was committed by B. It was the offence of dacoity. So, if somebody shields a dacoit, then what would be the punishment? Imprisonment of either description for a term not exceeding 3 years and also liable to fine. Now, let us talk about a provision which is act caused by inducing person to believe that he will be rendered an object of divine displeasure. See, even today there are many people who are very superstitious, who believe in miracles, who believe that maybe if I do something wrong, I would be punished by some supernatural powers. And if you play upon such feelings of a person, if you try to scare a person by evoking their religious sentiments or their beliefs in the supernatural or anything, then that is also a punishable offence. What does the law say? Whoever voluntarily causes or attempts to cause any person to do anything which that person is not legally bound to do, or to omit to do anything which he is legally entitled to do. How is that done? By inducing or attempting to induce that person to believe that he or any person in whom he is interested will become or will be rendered by some act of offender an object of divine displeasure if he does not do the thing which it is the object of the offender to cause him to do, or if he does the thing which it is the object of offender to cause him to omit, shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine or with both. Look at the illustrations. A sits dharna at Z's door with the intention of causing it to be believed that by so sitting he renders Z an object of divine displeasure. A has committed the offence defined in this section. Illustration B. A threatens Z that unless Z performs a certain act, A will kill one of A's own children. Under such circumstances, that the killing would be believed to render Z an object of divine displeasure. A has committed the offence defined under this section. Now, an offence which is something which usually people ignore. Suppose there is a person who is drunk and he is creating a disturbance in public place. That in itself is a punishable crime. What does the law say? Section 355 penalizes misconduct in public by a drunken person. What does the law say? Whoever in a state of intoxication appears in any public place or in any place which it is a trespass in him to enter, and there conducts himself in such a manner as to cause annoyance to any person, shall be punished with simple imprisonment for a term which may extend to 24 hours or with fine which may extend to 1000 rupees with both or with community service. So, what is punishable is misconduct by a drunken person either in a public place or by trespassing in someone else's property, and there what the person does, he conducts himself in a manner that someone else has been annoyed because of that. So, although it is just a token punishment which has been prescribed under law, but nonetheless the message goes out loud and clear that if any person has to consume any kind of an alcohol or intoxicating substance, then the person is supposed to conduct himself in a proper and sober manner, and in case the person is not able to control himself, then the person better confine or restrain himself to his own house or in a place where he is not going to cause any annoyance to anyone else. Now, let us talk about the offence of defamation. See, defamation in most of the countries across the world is treated as merely a civil offence. But we in India, despite so much of opposition from so many quarters, we have continued to retain defamation as not merely a civil offence, but also a crime. So, how does the law define the crime of defamation? Section 356 of the BNS says, whoever by words either spoken or intended to be read, by signs or by visible representations, makes or publishes in any manner any imputation concerning any person, intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said, except in the cases hereinafter accepted, to defame that person. But then there are so many exceptions also which are attached to section 356. First we will deal with the explanations. Explanation 1. It may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living and is intended to be hurtful to the feelings of his family or other near relatives. See, right to reputation is a right which the law gives even to deceased persons. Even the right to your reputation remaining unharmed after your death is there, which is given to all persons. Then explanation 2. It may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. Explanation 3. An imputation in the form of an alternative or expressed ironically may amount to defamation. Sometimes certain ironical statements may also be defamatory in nature. Explanation 4. An imputation, no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers the moral or intellectual character of that person or lowers the character of that person in respect of his caste or of his calling, or lowers the credit of that person or causes it to be believed that the body of that person is in a loathsome state or in a state generally considered as disgraceful. Look at the illustrations. Illustration A. A says, Z is an honest man, he never stole B's watch, intending to cause it to believe that Z did steal B's watch. This is defamation unless it falls within any of the exception. A is asked, who stole B's watch? A points to Z, intending to cause it to be believed that Z stole B's watch. This is defamation unless it falls in any of the exceptions. So, you see, whether by words which could be ironically expressed or by expressions by gestures, it could be in any way the defamation takes place. A draws a picture of Z running away with B's watch, intending it to be believed that Z stole B's watch. This is defamation unless it falls under the exceptions. So, what are the exceptions? Now, let us discuss the exceptions to the crime of defamation. Exception 1. It is not defamation to impute anything which is true concerning any person if it is for the public good that the imputation should be made or published. Whether or not it is for the public good is a question of fact to be determined on the basis of peculiar facts and circumstances of each and every case. Exception 2. It is not defamation to express in good faith any opinion whatever respecting the conduct of a public servant in the discharge of his public functions or respecting his character so far as his character appears in that conduct and no further. Exception 3. It is not defamation to express in good faith any opinion whatever respecting the conduct of a person touching any public question and respecting his character so far as his character appears in that conduct and no further. Look at the illustration. It is not defamation in A to express in good faith any opinion whatever respecting Z's conduct in petitioning government on a public question, in signing a requisition for a meeting on a public question, in presiding or attending at such meeting, in forming or joining any society which invites the public support in voting or canvassing for a particular candidate for any situation in the efficient discharge of the duties of which the public is interested. Now, exception 4. It is not defamation to publish substantially true report of proceedings of a court or the result of such proceedings, even though they might be affecting someone. But if it is a true report, there is no harm in publishing the same. Then, look at the explanation. A magistrate or other officer holding an inquiry in open court. What is an open court? A place where everybody has the freedom to go and attend the proceedings. So, a magistrate or other officer holding an inquiry in open court preliminary to a trial in a court is a court within the meaning of the above section. Now, exception 5. It is not defamation to express in good faith any opinion whatever respecting the merits of any case, civil or criminal, which has been decided by a court, or respecting the conduct of any person as a party, witness or agent in any such case, or respecting the character of such person as far as his character appears in that conduct, and no further. Illustrations. A says, I think Z's evidence on that trial is so contradictory that he must be stupid or dishonest. Now, A is within this exception if he says this in good faith. What is important here is bona fides. In as much as the opinion which he expresses respects Z's character as it appears in Z's conduct as a witness and no more. So, his comments are confined to what Z has said as a witness. That is it. Then, but if A says, I do not believe what Z asserted at the trial because I know him to be a man without veracity. Now, what has happened? He has commented upon his character outside his capacity as a witness. So, A is not within this exception in as much as the opinion which expresses Z's character is an opinion not founded on Z's conduct as a witness. So, this would not be covered under the exception. Exception 6. It is not defamation to express in good faith any opinion respecting the merits of any performance which its author has submitted to the judgment of the public, or respecting the character of the author so far as his character appears in such performance and no further. A performance may be submitted to the judgment of the public expressly or by acts on part of the author which implies such submission to the judgment of the public. Illustration. A person who publishes a book submits that book to the judgment of the public. Now, the public are free to criticize your book, but if they are criticizing you as a person, that would not be covered under this exception. But what is covered is expression of your views in the form of a book which you have submitted to public judgment. A person who makes a speech in public submits that speech to the judgment of the public. Similarly, an actor or singer who appears on a public stage submits his acting or singing to the judgment of the public. A says of a book published by Z, Z's book is foolish, Z must be a weak man, Z's book is indecent, Z must be a man of impure mind. A is within the exception if he says this in good faith, inasmuch as the opinion which he expresses of Z respects Z's character only so far as it appears in Z's book and no further. But if A says, I am not surprised that Z's book is foolish and indecent, for he is a weak man and a libertine. A is not within this exception inasmuch as the opinion which he expresses of Z's character is an opinion not founded on Z's book. Exception 7. It is not defamation if a person having over another any authority either conferred by law or arising out of a lawful contract made with that other, to pass in good faith any censure on the conduct of that other in matters to which such lawful authority relates. Illustration. A judge censuring in good faith the conduct of a witness or of an officer of the court, a head of a department censuring in good faith those who are under his orders, a parent censuring in good faith a child in the presence of other children, a schoolmaster whose authority is derived from a parent censuring in good faith a pupil in the presence of other pupils, a master censuring a servant in good faith for remissness in service, a banker censuring in good faith the cashier of his bank for the conduct of such cashier as such cashier, are all within this exception. Exception 8. It is not defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over that person with respect to the subject matter of the accusation. Look at the illustrations. A in good faith accuses Z before a magistrate. If A in good faith complains of the conduct of Z, a servant to Z's master, if A in good faith complains of the conduct of Z, a child to Z's father. So, here A would be within this exception. Now, exception 9. It is not defamation to make an imputation on the character of another, provided imputation be made in good faith for protection of interest of the person making it, or for any other person, or for public good. Illustration. A shopkeeper A says to B, who manages his businesses, sell nothing to Z unless he pays you ready money, for I have no opinion of his honesty. A is within the exception if he has made this imputation on Z in good faith for the protection of his own interests. A magistrate in making a report to his own superior officer casts an imputation on the character of Z. Here, if the imputation is made in good faith and for public good, A is within the exception. Then exception 10. It is not defamation to convey a caution in good faith to one person against another, provided such caution be intended for the good of the person to whom it is conveyed, or of some person in whom that person is interested, or for the public good. So, whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, and whoever prints or engraves any matter, knowing or having good reason to believe that such matter is defamatory of any person, then punishment would be simple imprisonment for 2 years, and whoever sells or offers for sale any printed or engraved substance containing defamatory matter, knowing it contains such matter, then punishment would be simple imprisonment up to 2 years. So, you see, defaming anyone else, the concept of community service has also been introduced herein. Now, section 357. Now, this is again usually which is treated as a civil offence, but here because there is someone who is dependent on you for the necessities, and if you exploit the dependencies of a person, if you do not do something for those people who are so vulnerable and totally dependent on you, wherein you have a legal obligation towards such a person, then this is not merely a civil offence, it would be considered as a crime. And that is why, what does section 357 say? Breach of contract to attend on and supply wants of helpless person. So, whoever bound by a lawful contract to attend on or to supply the wants of any person who, by reason of youth or unsoundness of mind or of a disease or bodily weaknesses, is helpless or incapable of providing for his own safety or supplying his own wants. So, if you, being bound by a lawful contract, voluntarily omit to do so, then punishment would be imprisonment for either description which may extend to 3 months, and it would also entail a fine up to 5,000 rupees. So, people who by reason of youth, that is who are young, we are talking about children here, young age people, or of unsoundness of mind, suffering from any kind of a mental illness, or any disease or bodily infirmity owing to which the person is in a helpless situation, the person cannot take care of himself and the person cannot provide for himself. And if you are legally bound by a contract to provide those, and if you do not do something which you are legally enjoined to do by that contract, then this is not merely a civil offence. The law treats it as a crime for which there is a punishment of imprisonment up to 3 years and also fine up to 5,000 rupees. Then coming to section 358, repeal and savings. Now, this is the last provision of the Bharatiya Nyaya Sanhita, and this is a provision which was not there in the Indian Penal Code. Why? Because it was a new enactment, whereas the BNS has come into effect by repealing the old Indian Penal Code. So, what does this section say? It says the Indian Penal Code is hereby repealed. It is no longer in force. Notwithstanding the repeal of the code referred to in subsection 1, it shall not affect the previous operation of the code so repealed or anything duly done or suffered thereunder. So, if anybody has been tried and punished as per the provisions of the IPC, that would stay. See, criminal laws are always prospective in operation. So, till the date BNS is not implemented, the date has been notified as 1st July 2024. Before that, if anybody commits a crime, the person shall be booked under the IPC and the trial shall be conducted in accordance with the provisions prescribed under the IPC and CRPC, and they would not be invalidated just because the next day BNS comes into operation. Those will remain correct, those will remain legally valid. Or any right, privilege, obligation or liability acquired, accrued or incurred under the code so repealed, or any penalty or punishment incurred in respect of any offences committed against the code so repealed, or any investigation or remedy in respect of any such penalty or punishment, or any proceeding, investigation or remedy in respect of any such penalty or punishment as aforesaid, and any such proceeding or remedy may be instituted, continued or enforced, and any such penalty may be imposed as if that code had not been repealed. Notwithstanding such repeal, anything done or any action taken under the said code shall be deemed to have been done or taken under the corresponding provisions of the Sanhita. So, this is a deeming provision. Then the mention of particular matters in subsection 2 shall not be held to prejudice or affect the general application of section 6 of General Clauses Act 1897 with regard to the effect of the repeal. So, students, because of time constraints, we cannot discuss in detail certain other provisions such as offences related to elections, offences relating to Army, Navy and Air Force, offences relating to coin, currency notes, bank notes and government stamps. But by and large, we have covered almost all of the provisions of the Bharatiya Nyaya Sanhita, and I am sure at the end of this course, you must have had a more clearer and a better understanding of what Bharatiya Nyaya Sanhita 2023 is all about. Thank you and have a great day.